6 weeks following the guilty verdict, the defendant text messaged an admirer. We are just one day away from the sentencing of Kouri Richins. The state has submitted their sentencing memo. We're going to talk about that today. We have some interesting updates, I think. This sentencing had originally been scheduled for the afternoon. The sentencing is starting tomorrow at 9:30 a.m. Mountain. Let's take a look at the sentencing memorandum from the prosecution. On Valentine's Day 2022, Kouri Richins tried and failed to murder her husband and the father of her 3 young children, Eric Richins. Over the next 17 days, she did not think, quote, "What have I done?" Rather, she thought, "How can I do better?" Damn. And then she murdered Eric in the presence of their children using poison and for money. Such a person should never again lurk among the rest of us. Holy spicy Bloodworth. Her children should never worry that they may one day encounter her. Accordingly, the state requests that the court impose a sentence of life in prison without parole. Kouri Richins has earned it. Her children deserve it. Only this court can order it. The options for the court tomorrow, and there are options. This could be a 25 to life case, which gives Kouri Richins the opportunity to be released from prison in the future, or life without the possibility of parole. It is clear to me that the state is asking for life without the possibility of parole. I think this is a case where life without the possibility of parole is very, very much on the table. The state's sentencing request. Count 1, aggravated murder. The court should order the defendant serve life in prison without the possibility of parole. Attempted aggravated murder. The court should order the defendant serve 5 years to life in prison consecutive to any other sentence. Consecutive means after. Also, the fact that attempted aggravated murder has a floor of 5 years is fucking insane. Count 3, insurance fraud. The court should order the defendant to serve 1 to 15 years in prison consecutive to any other sentence. So it would add. Count 4, insurance fraud. The court should order the defendant to serve 1 to 15 years in prison consecutive to any other sentence. Count 5, forgery. The court should order the defendant to serve 1 to 5 years in prison consecutive to any other sentence. Utah's sentencing is open-ended for the prison parole board to determine. So when you see that range of 1 to 15 years, the court can't say it's 15, bye-bye. The court can basically sentence her to 1 to 15 consecutive, and then the prison gets to decide if it's 1, 2, up to 15. But here, it will matter most if on count 1, she gets 25 to life, and then the other things get added consecutive. Because then you would have to serve 25, then you would have to serve 5, then you would have to start serving the 1 to 15, then the 1 to 15 and onward. So it's hard to really apportion how many years it would be. In California, you could just calculate this out. But in Utah, there's that range that does not become more final. Moving on. The court should enter a continuous protective order in favor of Eric Richins' family members that prohibits the defendant from contacting them unless they first initiate contact. And prohibits her from maintaining or benefiting from the insurance on the lives of the children. And then they list out all of the family members. They go on to ask for restitution. Look at this. The court should order the defendant to pay restitution to Auto Owners Insurance Company in the amount of $1,017,018.49 and True Stage Insurance Company in the amount of $352,562.61. Do you think the defense is going to argue that they need this to be set over for a separate restitution hearing? Probably. Let's see if there's any more restitution in this. There is. The court should order the defendant to pay recoupment to Summit County in the amount of $1,391,943.98. They're definitely going to ask for a restitution hearing. If they're entitled to it, I don't know if they are. The court should sentence the defendant to life without parole on count 1. The nature and circumstances of the crime are irrational. All right. Continuing on with the state's sentencing memorandum. The defendant murdered her husband in the presence of their young children, using a poison for money and after trying and failing to murder him 17 days earlier. The Utah legislature recognizes that homicidal poisoning and murdering for money are each so heinous as to individually warrant the death penalty. Here, the jury found the defendant guilty of both aggravators. The impact on the victim's family is irreparable. It starts with, fathers are not meant to bury sons. And it starts that way because Eric Richins' mother is predeceased. It's not a slight to Eric's mother. Eric's mother is predeceased. Bloodworth goes on to say that losing a sibling is losing a piece of yourself. But there are no greater victims in this case than Eric's 3 young boys. The defendant took both of their parents from them. Agreed. The aggravated murder was a crime of domestic violence in the presence of children. Eric Richins was a good husband. He cared and provided for his wife and even protected her from herself. Eric was a good father. He knew the defendant tried to murder him on Valentine's Day. And he also knew that it was unsafe for his children if he were to leave the home. Eric died protecting his boys, and they knew it. As we get into the next part, we are going to be talking about things that the children have said. CR was 9 years old when his mother murdered his father. He is now 13 and wears his father's clothes to school. It goes on to say that following Eric's death, DCFS supported a finding of emotional and physical abuse by the defendant against CR. Sentencing Exhibit A. We do not have Exhibit A. We're not going to go through Exhibit A. But the kids were in the home. He and his brothers have participated in intense therapy since the defendant was arrested 3 years ago. Good. I'm so glad to hear it. It goes on to say what CR wants the court to know. And I'm glad the kids have had the ability to send letters to the court. And yes, that is the type of thing they can work on with their therapist to submit to the court. And I'm glad that they did. CR wants the court to know that my dad was a good person and very thoughtful and kind and helped whoever needed it. And goes on to say, quote, I'm afraid if she gets out, she will come after me and my brothers, my whole family. I think she would come take us and not do good things to us, like hurt us. I miss my dad, but I do not miss how my life used to be. I don't miss Kouri. I will tell you that. AR was 3 weeks shy of his 8th birthday when his mother murdered his father. The defendant made AR her alibi, thereby condemning her child to be a material witness. If called to testify at trial, AR would have recalled being put to bed early on March 3rd, 2022 without bathing, which was unusual for the boys. The television was playing loudly inside his parents' bedroom, and when AR tried to enter, he found he was locked out. AR used a broom to try to dislodge a key from above the door frame, intending to unlock the door and enter the bedroom. AR accidentally hit the wall with the broom, making a noise that attracted his mother's attention. She yelled at AR to go away. She later entered his room and asked him what he needed. AR pretended to be asleep because he was angry with her. Later during the night, his younger brother, WR, woke and tried to enter his parents' bedroom to sleep with them, as was his habit. WR also found himself locked out and slept in AR's bed instead. AR would have testified at trial that the defendant did not sleep in his room with him the night she murdered his father. The interviews with the children indicate that Kouri stayed locked in the bedroom to make sure that Eric was good and dead then, which is exactly what Bloodworth said in his closing argument. So now a lot of you have a question. Why didn't this come in at trial? If I were Bloodworth, and I'm not that smart, but if I were Bloodworth, looking at this case, I think I would do everything in my power to not call any of these children to testify. If there is any way you get to a guilty verdict without these kids sitting in a courtroom across from their mother to testify, you do it. If Kouri had testified, though, this would likely have come in at rebuttal. AR wants the court to know that, quote, my dad can't be my coach anymore. Oh, we're doing such a good job, Emily. And can't be at any of my games. He won't be at my birthdays. He can't teach me how to drive. He won't be at my graduation. He can't take me camping or fishing. It continues saying, quote, I don't want the defendant out of jail because I will not feel safe if she is out. With her in jail, I will be able to continue to feel safe and to live a happy and successful life without fear of her hurting me or anyone I love. WR was still in preschool when his mother murdered his father. He has now had to live half his life without his father and 3 years without his mother. His memories of both are limited. WR wants the court to know that when someone talks about Kouri, it makes me feel hateful and ashamed. She took away my dad. And if she got out, I would be so scared. I'm worried that she would take me away. Once she is gone, I will feel happy and I will feel safer and relaxed and trust people more. If the defendant serves 25 years in prison, she could potentially be paroled at age 57. Her sons will be 36, 35, and 30, and will likely have their own families. The boys deserve finality and should not have to revisit their father's murder at future hearings. That is an excellent point. That is an excellent point, Mr. Bloodworth, that if she gets 25 to life, they will likely be contacted by prisons and parole for what they think. There will always be a ticking clock on what's going to happen next. There will always be a countdown to will she get out. And the only way to stop that clock and to stop that countdown from living inside them forever is for LWOP. That is the only thing that shuts that door. Given the tremendous amount of trauma and upheaval that the defendant inflicted upon their children, this court should ensure that she does not harm their adulthood. Not only should the defendant serve her life in prison, but she should serve her boys' lives in prison. This is the best closure her children can hope for. Only this court can give it to them. Goes on to say that Katie and Clint are now raising 3 boys that require extraordinary love, support, and stability. It is best for the boys, and everyone is thriving, but Katie and Clint never planned for it. Katie never planned to administer an estate and trust or tackle vindictive litigation. Gene never planned to work the family ranch at his age without Eric. Katie and Amy both live with guilt for not doing more to protect their brother from his wife. The aggravated murder's impact extends beyond the Richins family. Josh Grossman bears the weight of knowing that he contributed to the defendant's motivation to murder Eric. It has gutted him. God, you could see it when he testified. Chelsea Barney bears similar weight, knowing that the defendant murdered Eric in some measure to salvage Miss Barney's life savings. It haunts Carmen Lauber that she unknowingly provided the defendant with the fatal drugs. Cody Wright and Josh Kays question whether they could have done more to save their friend. The defendant's character is irredeemable. The defendant is transparent. Evidence of her character is known from all stages of this proceeding, to include her prioritizing a facade of success over everything, her fraudulent borrowing, her stealing her best friend's life savings, her persistence in murdering Eric after failing on Valentine's Day, her self-publishing a children's book for money and attention, and the aim of her walk the dog letter, among a slew of other examples. The defendant cannot check her ambition. I mean, I got another word for it too. Or her sense of entitlement. When confronted, she lies. When she feels aggrieved, she attacks. And she certainly feels aggrieved. She always has. In the immediate aftermath of the guilty verdict, the defendant blamed a corrupt prosecution, a corrupt judge, and unfair Summit County jurors. 6 weeks following the guilty verdict, the defendant text messaged an admirer. Quote, "I will," all caps, "I will expose this county," that paid like $2 million for her to have a fleet of defense attorneys. "I will expose this county, the prosecution, the judge, the Richins, the investigation, all of it." Oh, it is full burn book style. Girl, this investigation looked every which way but at you to begin with. So they can lock me away for now. That's fine. It's going to come back on them. It will come to an end. Well, not the way you think. Not this year or next, but I'm not going away. I won't be silent. There's a apostrophe in that, but whatever. I am going to expose them all for what they have done to me. I'm going to expose them all for what they have done to me, my kids, my family. This injustice, they picked the wrong one. They think sentencing is quote unquote the end, quote unquote closure. It's just the beginning. They haven't seen anything yet. Winky emoji. The prosecution goes on to say, most telling of her character, the defendant attacked Eric. Within hours of her arrest, she, for the first time, blamed Eric for his own death. And that's Exhibit E and E transcript. From jail, the defendant and her family engaged in quote unquote open season on Eric the Dead. That must be what they referred to him as between them, and that's why it's in quotes. Releasing what they believed would be damaging information about Eric to the media. During trial, the defendant falsely accused Eric of having an affair with a coworker and a homosexual affair with one of his best friends. The Richins children are familiar with the inescapable media coverage of this case, right? Because they go to school. Many of the defendant's attacks against the Richins family preeminate the record, right? Because she started that lawsuit. Oh, we got to the throat punch. Look at this. Look at this. Look at this. For example, why did throat punch become one of my favorite words in this case? For example, she throat punched Amy Richins 2 days after murdering Eric when Amy informed her of the Eric Richins living trust. Yeah. Super normal reaction to attack your sister-in-law. I am being sarcastic. Eric created the trust to protect Kouri and their children. 4 days later, she hired counsel to breach the trust. She told Jean Richins that Eric died of the same lung mold that killed Jean's wife. Cruel. Period. In the Walk the Dog letter, the defendant instructed her mother to release photographs of Katie's young children to the media and wrote, quote, "Bring me home and then we'll get those damn bitches." When confronted with the letter, the defendant insisted in the face of all reason that it was part of a freaking book. Emily, where does that quote come from? Kouri's jail calls, because they've been in other motions. Other of the defendant's attacks against the Richins family are new to the record. Oh no, there's more? For example, when the estate's investigator, which would be Mr. Gabler, I would imagine, when the estate's investigator found bank statements with Kouri Richins Realty's account header and CNE's account details, The defendant accused Katie and hired counsel to advocate for the criminal prosecution of Katie. While detained pretrial, she caused her family members to pursue federal firearms charges against Jean for removing Eric's firearms from the Willow Court home for safekeeping. That's what she was trying to do? Of course, Eric Richins' family wanted to remove weapons from the home before Kouri was removed from the home. Kouri was at the home for a year after Eric died, and Eric's family was like, she did that. Of course you don't want her to have guns at the home. Filed false reports with DCFS against Katie and reported Amy Richins to the police for marijuana possession. The fucking hypocrisy. What else did she do? To this day, the defendant maintains insurance policies on the lives of her children. The Richins family will not be safe if the defendant is ever paroled. The defendant's attacks extend beyond the Richinses. While detained pretrial, the defendant caused her family members to file unfounded bar complaints against the Summit County attorney and chief prosecutor and post a gay dating profile of the lead detective online. The defendant also made an unfounded criminal complaint to the FBI about Eric Richins' business partner. The defendant's character is evident despite her well-crafted facade. I mean, it's not that well-crafted, let's be honest. Eric surviving Valentine's Day, 3 years of pretrial detention, and a resounding guilty verdict has only amplified the worst of her character. It did not remedy it. She has expressed no remorse and has indeed publicized the opposite. Calling the judge corrupt is a real bold choice. The irrational nature and circumstances of the aggravated murder, its irreparable impact on the Richins family and others, and the defendant's irredeemable character prove overpowering aggravation. Any mitigation the defendant presents will only be more facade. It is all she has. The read. Oh boy. Well, I don't know if I even expect the defense to respond after this. Like, what the fuck do you say? The prosecution goes on to say, but even if credited, like even if the court is like, okay, this is a mitigating factor, but even if credited, it cannot outweigh the aggravation. Accordingly, the defendant has earned the maximum punishment short of death, and the public safety requires her permanent incapacitation. Yeah, incapacitation by incarceration. She is well established that rehabilitation is beneath her. LWOP, combined with the intense publicity cultivated by the defendant and her counsel, will also deter would-be prisoners from coldly murdering their spouse and their child's parent. The court should sentence consecutively on counts 2 through 5. The gravity of the attempted murder is that the defendant learned from her mistakes. She learned to obtain quote-unquote something stronger and to administer it in a way that prevented Eric from realizing the poison's effects until it was too late. It goes on to say that the gravity and circumstances of the frauds and forgery punch above the charge's weight because they encompass the defendant's motive for murdering Eric and the pecuniary gain aggravator. The defendant's character, as discussed in section IC supra, is irredeemable. Accordingly, the defendant earned distinct punishment for counts 2 through 5, and the court should sentence them consecutively to any other sentence, one after the other after the other. The court should enter a continuous protective order in favor of Eric Richins' family members. I like this. The defendant was convicted of domestic violence, aggravated murder, and attempted aggravated murder. Utah's criminal protective order statute provides that when a perpetrator is convicted of a domestic violence resulting in a sentence of imprisonment that is to be served after conviction, the court shall issue a continuous protective order at the time of sentencing, limiting the contact between the perpetrator and the victim unless 1, the court determines by clear and convincing evidence that the victim does not have any reasonable fear of future harm or abuse. Protection may include any order, quote, the court considers necessary to fully protect the victim and members of the victim's family. And then it cites the Utah Code. Here, Eric Richins is the only quote unquote victim under Utah's victim crime statute. Paradoxically, Eric Richins' family members, including his children, are not quote unquote victims. It is evident that Eric Richins does not have a reasonable fear from future harm or abuse, which is the Criminal Protective Order statute threshold inquiry. Thus, the Criminal Protective Order statute yields the absurd result that family members of a domestic violence murder victim are left unprotected when family members of all other domestic violence crimes can be protected. It's a good argument. Bloodworth is making sure to kind of close the legal loophole or question that if there was just an attempted murder and the victim was alive, then there could be a protective order for the victim and the victim's family. But if the victim is deceased, then you can't have a protective order on the victim and the family. So why shouldn't you be able to just have one on the family? And so kind of closing that loophole on the result and asking the court to close that loophole that the law clearly doesn't intend that decedents' families aren't protected if the court finds that it's reasonable. They go on to say that this is where the absurdity doctrine comes into play. He's not making that one up, you guys. There are circumstances in the law where the legislature is trying to protect a certain circumstance, but without adding a few words or without carving out an example, you can have this mixed result that if the victim's alive, it's result A, but if the victim's dead, it's result B, but result B doesn't make any sense. And so absurdity is not a takes EV backsy, but meaning that you can't intend to have these separate results. Bloodworth says this is where the absurdity doctrine comes into play. Courts will apply the absurdity doctrine when the operation of the plain language is so overwhelmingly absurd that there's no rational legislature that could have intended the statute to operate in such a manner. This standard is satisfied only if the legislator could not reasonably have intended the result. The defendant's conduct and the victim impact statements firmly establish that it is necessary for the court to protect CR, AR, and WR from their mother, as well as Eric's father and his sisters and their families. Anyone can appreciate the family's fear resulting from the defendant maintaining insurance on the boys' lives. Well, and her statement that this shit ain't over yet and get me out of here and we'll get those bitches. They go on to say that the court should order the defendant to pay restitution. The defendant received over $1 million from Auto Owners Insurance Company, over $352,000 from True Stage Insurance Company as the beneficiary of insurance on Eric's life. The insurance companies paid out as a result of the defendant committing aggravated murder as convicted in count 1. Moreover, True Stage paid out because the defendant committed insurance fraud and forgery as charged in counts 3 and 4. Accordingly, the court should order the defendant to pay restitution to the insurance companies in the amounts listed. I'm not reading them again. The court should order the defendant to pay recoupment to Summit County. After Ray, Quinney, and Nebeker abruptly withdrew from this case in May 2024, the court declined to require the defendant to complete an affidavit of indigency, citing Fifth Amendment concerns. The court found that the defendant was indigent on the sole basis of former counsel's representation that, quote, the defendant does not have access to financial resources sufficient to retain private counsel. Summit County thus became statutorily obligated to provide defense services to the defendant. The cost of those services will exceed $1.3 million. That did not encompass the amount of prosecution. That was the amount of defense. If the court learns that an individual provided with those services is in fact not indigent, the court shall order the individual to pay the defense system the cost of the services. The defendant continues to litigate claims to Eric Richins' premarital home and a share of the trust res. To the extent any of those assets or other assets are adjudicated to the defendant's property, the court must order the over $1.3 million of those assets paid to Summit County as recoupment for the defense services. If she wins on any of those civil cases, which she may not, but if she wins on the civil cases, it should pay back the system to pay for her lawyers. The court should sentence the defendant to life without parole. Among the state's other sentencing requests, this sentence is appropriate considering the crimes that she committed, their impact on her children and Eric Richins' family members, and her irredeemable character. This sentence serves the interests of society, which underlie the criminal justice system. Most importantly, no other sentence can provide the children, CR, AR, and WR, the comfort and protection that they need and deserve. Holy shit, that's a sentencing memo. Law Nerd, it's time for a monthly reminder that your data is exposed everywhere. And thank you to today's sponsor, Incogni, for helping me keep my and my family's information off of the internet and away from data brokers and others. And we've also seen information from the FBI that foreign adversaries have found a way to hack into foreign-made internet routers. You know, the one your phone company gives you? They can be hacked into remotely, and then everything you are doing on the internet from your home is exposed. And yes, there are some steps we can take to protect ourselves online. Yes, that would be a ton of work, but that's what Incogni's for, because their process is fully automated. And if you ever run into any roadblocks that the fully automated process doesn't work for, you can use their custom removal tool. And once you take back control of your data, it reduces the people who have access to you. It protects you online and off, and reduces those scams that can use your information against you or your family members. And if for any reason you're not happy with Incogni, they have a 30-day money-back guarantee, so you can try it for yourself and you can cancel anytime. Law Nerd, I know you're ready to check it out and take back control of your personal data with Incogni. Just go to incogni.com/Emily and use code Emily to get 60% off annual plans. And Law Nerd, I know you will rely on Incogni as much as I do. Now let's get back to today's case brief. There will be subsequent hearings to sentencing for Kouri Richins because she still has the financial crimes case. Remember, her defense attorney said that they would, and reluctantly so, that they would take on standing in essentially as her attorneys on the financial crimes case, but they did not agree to be appointed on that case. She will need new appointed criminal defense attorneys for the financial case that's following this. And that financial case is just trailing behind this one until this is done. Once this case is done and sentenced, they might find a way to resolve it. I imagine they are going to want restitution ordered to Barney for the loss of life savings and to others. But if she gets sentenced to LWOP, I imagine they will be able to resolve that other case, because truly what would be the point of the money and resources spent prosecuting it? We would all be happy to see another trial. Summit County, on the other hand, might be like, we have spent enough money and time and energy on Kouri, but we're going to keep an eye on the financial crimes case that's trailing this one, because there is another date set for a status hearing in June. So she's going to need new lawyers. She already needs new lawyers in all the civil cases. She's going to need new lawyers on that criminal case. The sentencing tomorrow, the judge has set aside the entire day. We will be streaming it live. Bring your Kleenex. We will let you know in the Law Nerd app when the impact statements are being read, when the impact statements are done, when the defense is presenting their side and any witnesses and mitigation, when the attorneys are arguing. We're going to give you a lot of notifications tomorrow. When the attorneys are arguing their side of the case, and when the judge goes to pronounce sentencing. Will that go over lunch? Will that not go over lunch? I do not know. I plan on being with y'all all day tomorrow. Sentencing is supposed to start at 9:30 Mountain. So tomorrow is going to be an emotional day. I did not expect sentencing memo to be an emotional day, because yikes. What we have learned from this memo is there is still more that we don't know. There was a lot of new information in this memo. New information that Kouri, after the verdict, is like promising her revenge. If I'm the judge and I'm looking at what the balance is of, is there remorse here and is a protective order needed? I'm going with yes, a protective order is needed, and no, there's no remorse here. And then when you add that to what we learned for the first time in this sentencing memorandum, we saw brief statements shared from what the children have written to the court, saying that they are afraid if Kouri is released, referring to Kouri as she and as Kouri, and talking about the fact that their life before their father was killed was not great. We also saw, for the first time, detailing of what the middle child, who was asleep downstairs, would have testified to. And that new information is that Kouri did not go and fall asleep in her child's bedroom. That when the middle child and the youngest child tried to go into their parents' bedroom that night, they found the bedroom door locked. And the middle child tried to get the key off the top of the door frame with a broom that banged against the wall. And then Kouri yelled at them to get back to bed, then did go into the room to check if they were asleep. And the child pretended to be asleep because they were mad at Kouri. Her entire statement was, I went into my kid's room and fell asleep. I got up at 3 a.m. I went into the bedroom. I got into bed. It felt weird. Eric felt too heavy. On and on. And what we learn here is that Kouri was in the bedroom, locked in the bedroom with Eric, which gives new emphasis to Bloodworth's closing argument when he said she didn't just want Eric dead, she wanted him good and dead. Because based on this, it sure seems like she waited in the bedroom from after she made those drinks till just around 3 a.m. to call law enforcement to ensure that this time he was going to be dead. She talked about the children trying to come into the room on the 911 call. At that time, I had thought it was related back to her calling 911 and being loud and trying to kind of work herself up into emotion. But I wonder if when she was talking about her kids trying to come into the room, she was actually referencing earlier in the evening. So there's a lot more to this case at sentencing than I expected. There is still more to come. Thanks for joining me. If you enjoyed this episode and don't want to miss updates on your favorite cases, you're going to need the Law Nerd app at lawnerdapp.com. That way you can stay in the loop on the cases that matter most to you, and you never know when you're going to catch feelings for a new case. So make sure you get it for free on iOS and Android. Thank you for being here, and thank you for being a Law Nerd.